everyone, and welcome to IMREAL.LIFE. This is another FLAST review of a parenting case, and it's an appeal, and this one is a really controversial case. With the new family law court merger and the new rules that are in place, this case has a look at all of the existing law, the application of some of the new rules, and wow, is all I can say. I'll let you guys be the judge when we go through this, but I'm going to start off by saying that this is a case that involves a Rice&Asplund question. After you get a final decision from the court, in order for you to go back to court and ask the court to change that decision, what it's been ruled upon in the case of Rice&Asplund, that you must demonstrate that there's been a significant change in circumstances to warrant the court reviewing that case, to warrant the court reopening the case, to warrant putting the parties through the stress and strains of what goes on in a litigated court proceeding, and to also consider the impact of that on the children. And this case covers all of that, all of it. And just to give you guys a bit of a guideline here, some of the cases that we've covered before in the past that are Rice&Asplund, following the court's exercise of discretion, there is no doubt that the father has been ultimately wholly unsuccessful because he couldn't demonstrate significant changes. In the next case, parties dispute final parenting orders. The court concluded that the father has not established that there's been a significant change in circumstances since the final orders were made. Father seeks fresh application, and the court ordered that the application filed by the father be dismissed because, again, there was no change in circumstances that he could demonstrate. And generally speaking, when they're looking at these change in circumstances, again, dismissed, because it's not in the best interest of the kids to have the case continue. So that's what I said before. Sometimes as part of that consideration, one of the key factors is, should you reopen the case? Because what impact will that have on the children to reopen this case and have the parents relitigate things? Another case here, clearly it's not in the interest of the children to have repeated applications before the court concerning arrangements for living arrangements. So I think you're getting the drift that it's not an easy thing to overcome this Rice&Asplund hurdle. The court is not satisfied that the mother established a change of circumstances. So it's not always going, against the father. Here it's gone against the mother. And court dismisses the mother's application for her failure to prove change in circumstances that would warrant a reopening of parenting proceedings. I highlight these because you can see time and time again the court is very reluctant to change their position. And here we go. The father opposes a decision of the Judicial Registrar. Okay. So this is an appeal of the Registrar's decision, and the Judicial Registrar ordered the parties serve a genuine step certificate that the parties and children born in 2009 and 2007 are directed to attend a child court expert. The father filed an application for review of that, and he was simply seeking that order of the registrar be dismissed, the initiating application filed by the mother be dismissed. And the reasons he wanted it dismissed is essentially a Rice&Asplund type reason. So let's have a look at the facts of the case. The mother filed an initiating application seeking orders to discharge final parenting orders made by consent on the 6th of March 2017. So, 2017 to 2021, you've got 4 years have passed here. Worthy to note, in this case, the mother also had, this is her second attempt to change the orders. She filed one application in 2018, also seeking a review of the orders, but that one failed. And now the mother seeks to alter the frequency and duration of the time the children spend with the father, and she also seeks removal of a term in the 2017 orders that she personally delivered the children to the father's care at the commencement of his time with them. So she just wants to adjust time with and change it that she doesn't have to drop the children off directly to the father. Okay, the father filed an application for review of those orders made by the registrar, and he simply sought an order dismissing the initiating application. The court conducted a hearing of the application for review, and then the counsel for the father indicated that the father's position was somewhat more targeted than the terms expressed in the application. Mr. Othen contended that the mother failed to establish prima facie case that there has been a change in circumstances sufficient to meet the threshold required by Rice&Asplund, and that the mother had taken no steps to attend mediation, contrary to requirements of Order 9 of the 2019 orders. So in the original orders that were submitted and agreed upon by the parties in 2017, before they could go to court, apart from the court rules saying that, the orders themselves said that as well, that they should go to mediation before they can go to court. But here we have mum filing an initiating application, no mediation, and no Rice&Asplund significant changes. Mr. Othen, the lawyer of the father, submitted that consistent with the objective of finality in respect to parenting proceedings, there was a need to avoid children being exposed to disputation in the court. And accordingly, the counsel for the father, the order made by the registrar that the parties and the children attend appointments for the preparation of child impact report were contrary to the best interests of the children. So the father's lawyer is arguing both that there's no change in circumstances that warrant the court relooking this case, and on top of that, that it would be detrimental to the children. It's not in their best interests. It was submitted that the failure to attend mediation of some kind before commencing proceedings was a major failing because the dispute between the parties is likely to be narrow in scope. So, you have a narrow dispute here, no mediation, and is it in the best interest for this case to be litigated? So the question now here in this appeal is whether or not the application for review should be granted. So, the father's there saying, okay, the registrar made a mistake. Let's have a judge look at it and see if the judge can, review this position and whether or not the mother has made her case. Let's go to the analysis. Miss Gibson, counsel for the mother, refuted the suggestion that the initiating application was made improperly. She pointed out that the initiating application was filed before the commencement of the new rules in September, and further that the 2017 orders were made some years ago when the ages of the children were considerably younger, 4 years younger. And 4 years, for you to argue a Rice&Asplund case that the children are 4 years older and that is a significant change in circumstance, I've seen a lot of cases, go forward, and 4 years has never been enough of a gap to warrant a change in circumstances in many of the cases that I've seen before. So, how strong that argument is yet to be seen, and their circumstances had changed such that it was likely to be in their interest now, that their interest now would differ, that they would need to have less time with their father, or, something to that effect is what is being argued here. In addition, referred in the mother's affidavit, her financial circumstances have changed, and costs for the travel to comply with the orders and bring the children to the father is a second issue. So, is that enough to reopen the whole case? Is that enough now to get the children to have to go and see a court-appointed expert psychologist or social worker to write a report for the court? Is it enough to do all of these things? And, the case, in the end, the father's case was dismissed. The mother won. The mother won, and the mother won on the basis that there was apparently sufficient justification. The consequences of these orders are that the child impact report should be finalised by a court child expert, and subject to usual procedures, released to the parties prior to their participation in FDRC, Family Dispute Resolution. Let's have a look at the judgment here, because you've got to be asking here, how did this case prosper? How did she overcome that Rice&Asplund hurdle? So let's have a look here. Here's the judgment itself and the reasons for the judgment. Judge Taglieri. So this is his introduction. There's an application seeking orders to discharge final parenting orders made by consent in 2017. The mother seeks to alter the frequency and duration and the time of the children spend with the father. All right, let's scroll down a little bit further. And the review hearing, in essence, the counsel for the father, Mr. Othen, contended that at this juncture the mother failed to establish prima facie case that there was a change in circumstances sufficient to meet the threshold required by Rice&Asplund, and that the mother had taken no steps to attend mediation, which was a requirement of the orders. And consistent with the objective of finality in respect to parenting proceedings, there was a need to avoid children being exposed to further disputation. These are, this is a common rule that existed for a long time. According to the counsel for the father, the order made by the judicial registrar that the parties and the children attend appointments for the preparation of the child impact report were contrary to the best interests of the children, as it would implicate the children having to be again interviewed by a court child expert, and reliance was placed on Rice&Asplund and other authorities relating to the same essential ratio. I've marked in red here that children and the parties already attended the interviews. So the father, having been ordered by the registrar, despite the fact he's objecting here, complied with the order, came and was interviewed by the court child expert, and had the children interviewed as well. So this becomes an issue, throughout the case, that the fact that he actually complied with that registrar's order becomes an issue here. And that's why I've got it marked in red, and we'll touch on that a little bit later. It was submitted that the failure to attend mediation of some kind before commencing the proceedings was a major failing. And, that's the normal thing. The court normally requires, before you go to court, try mediation. Try and resolve the dispute yourselves before you bring the court into it. And the father wanted to stay the preparation of the court report experts' report now. And upon inquiry, counsel agreed that another option was to extend the stay order, because there was a stay order, a stay of the proceedings order, and conduct a separate hearing for the threshold of Rice&Asplund. So there was an option here that we have a separate hearing to decide, has the wife or has the mother met that Rice&Asplund threshold test. Now, the yellow text here that I've highlighted is the mother's counsel's argument that the 2017 orders were made 4 years ago, and the ages of the children were considerably younger, and that the circumstances have changed such that it was likely in their best interest now to be a different scenario or a different level of contact with the father. It was submitted that the new 2021 rules do not require determination of the so-called threshold Rice&Asplund issue. Now that's interesting. So the new rules do not require the determination of the Rice&Asplund issue as a separate question, and rather that the case proceed and that the court be mindful of Rice&Asplund principles. Wow. It was submitted that the wishes of the children have likely changed and her financial circumstances have altered, and Mr. Gibson referred the court to the exemption certificate from B Family Centre. It was submitted indirectly that the issue of that certificate somehow released the mother from mediating on Order 9.3 of the 2017 orders. So the mother's gone to B Family Centre and obtained a certificate of an exemption, that she was for some reason exempt from having to proceed with mediation according to them. Okay, Miss Gibson, that's the attorney for the mum, submitted that it was in the best interest of the children for their views to be gathered by the court child expert to be made known. With this additional information, the parties will be well placed then to participate in FDRC, pursuant to the new processes involving a registrar and the court child expert. She observed that it was mystifying that why the father's case was that the views of the children should not be heard, particularly given their ages. So we're into a bit of a controversy here where, I guess the father has objected to the mother going directly to the registrar, filing an initiating application without even attempting mediation, and now because the father's objecting to the children seeing the court child expert, she's taking that to mean that the father doesn't want the children's voice heard. Let's have a look what the court says. The father argues that there's a risk of psychological harm to the children being involved in litigation. So that's the father's counter-argument. And exposing and involving the children to the proceedings should only occur after the parties have attempted to reach agreement and failed. There's been no attempt to reach agreement. The mother's gone bang and he launched the initiating application with no attempt prior to actually reach agreement with the father. Okay. Ms. Gibson also sought to rely on a report from Child Safety Services dated the 21st of October. They talk about a report here, however, we don't get to know what was the content of that report. The father had only seen it on that day of the hearing, and he argued the initiating application by the mother still sought orders consistent with the father having significant time with the children, but slightly different times and intervals and durations to the 2017 orders. And in red I've put, this could not be the case where the mother argued that there was an unacceptable risk. So it looks like the mother was on one side of things arguing for some reason there's an unacceptable risk, and on the other side arguing, well, the father can still see the children, we just want to change the times a little bit and make it more convenient. He contended strongly that there was no evidence to family violence between the parties, and the relevant issues were merely about when and how much holiday time the father could have with the children. He therefore objected to the court having regard to the report, and the court has not considered the report as well. So the court sort of accepted the father's position here. So it's not that, meaning that wasn't the court has said, I have not considered the report, so therefore this has not been a factor in the decision-making process. We've got some more red lines here. The court says that being to manage cases consistent with the overarching purpose of resolving proceedings according to law and as quickly, inexpensively and effectively as possible. They're citing Lombardi and Ryder, a 2021 case, where Judge Alstegren, that's the Chief Justice, referred to this overarching purpose in another equally important context concerning abridgment of time. So normally if you want to go straight to the court without mediation, you need to file an application for abridgment of time. But it looks like that hasn't happened here either. The collection of various provisions of the Act, the new rules, and central practice direction also afford a degree of flexibility and discretion, including capacity to dispense with requirements of the Act or the rules. So, according to the new rules, the judge doesn't have to follow the rules. It's at the judge's discretion, and that is consistent with case management and overarching objectives. Now, the mother filed her initiating application, an affidavit, and a family dispute resolution exemption certificate. Okay, the primary purposes of the first court event are A, to ascertain whether any orders or directions can be made by consent. So the question here is, has the registrar done that? Has the registrar done that? You know, according to the father, the answer is no. According to the father, there's been no attempt to, reach agreement by the mother. No attempt to mediate. It's just gone straight to an initiating application. And, the second to that, the primary purpose of the first court event, which is where we're at now, is to ascertain whether the parties have complied with the pre-action procedures and made genuine attempt to resolve the issues in dispute unless it is unsafe to do so. And if not, to make provision for them to do so prior to the proceeding progressing further. Has that happened? Because apparently not. Let's move forward. A review of the affidavits filed by the parties discloses that the mother seeks different spend time with the orders for the children, and the evidentiary basis for this is set out in 28 to 38 of her affidavit. The father's affidavit sets out the basis for opposing the mother's proposed change. He identifies practical and personal difficulties with the proposed new orders due to his health and his location from Sydney Airport and costs. The father's affidavit also refers to unsuccessful proceedings by the mother in 2018. So this case was not her first time or first attempt to change the orders. The 2017 orders she tried to change in 2018 and failed. Questions of alleged alienation by the mother and whether the court should entertain making different parenting orders arose as a result. Ultimately, the submissions on behalf of the father distilled into an argument that I should order the parties to participate in family dispute resolution without the benefit of the parties knowing the children's views about the mother's proposed changes to the 2017 orders. So the father wanted to go straight to mediation. The father didn't want the children to be subjected to a court report writer interviewing them before they tried to mediate it. He was suggesting that the parents should try and work it out themselves. The overriding consideration in all children's matters, including when deciding if a threshold Rice&Asplund issue should be determined separately, is the best interest of the children. The view of the children, particularly the eldest, are relevant evidence to be considered and gathered according to paragraphs 5.11b and 5.13 of the Central Practice Direction. And the judge goes on to say that these provisions necessitate all relevant evidence to the dispute being obtained before the parties participate in FDRC. So, we're talking about new rules by the look of things. According to paragraphs 511B and 513 of the Central Practice Direction, the new directions since the merger of the family court, presumably, these provisions necessitate all relevant evidence to the dispute being obtained before the parties go to family dispute resolution conferences. How that can be achieved is unclear. How do you do that? How do you get all the relevant evidence to the dispute before you mediate, before you try and resolve the dispute? How does all that evidence get put forward, and how is it tested? So there's a bit of a question here as to how that is going to function. Ordering that the parties attend family dispute resolution in either way submitted by counsel for the father before the view of the children are known is also likely to simply stall and delay the inevitability of ascertaining the views of the children in this case. This will be contrary to the overarching purpose of case management enshrined in the statutory scheme referred to elsewhere in these reasons. There is no merit in requiring the parties engage in mediation or alternative dispute resolution outside the court, as this would likely come at an additional expense. I mean, these are all... I'm a mediator. So to read something like this that says there's no merit in requiring the parties to engage in mediation or alternative dispute resolution outside of the court because it'll come at an additional expense. Actually, you know what? With all due respect to His Honour here, Judge Taglieri, mediation does the opposite. It saves the parties money. It saves them having to engage in legal services, engage in costs of filing applications, engage in costs of application of affidavits and everything else that's happened to get even to this point here. Mediation could have avoided all of that if the parties reach a resolution. So, and to say that there's no merit requiring the parties engage in mediation is sort of contrary to everything that we've done before. Ultimately, I don't understand myself how this case has resulted in a decision that effectively overturns the principle of Rice&Asplund, that there be a significant change in circumstances, that parties engage in mediation before they go to court, that the parties make genuine attempts themselves before they even try mediation. None of that has happened here, and I've got to say that I'm baffled a little bit by this decision, and we'll keep a close eye on new decisions coming out of the court and how these new rules are being applied. But it really does seem like there's a bit of an upheaval in the way the law is being applied now under these new rules, and that there's been some significant changes to the processes where it opens the door for any final orders now to be contested 4 years down the track, and with going straight to the registrar. This is the case to cite. If you want a precedent to cite to say why a case ought to be reviewed and why the children should be dragged to court and interviewed by a court child expert for their opinion before mediation takes place, before FDRC takes place, and you're already able to initiate proceedings without getting a 60I, without applying for an abridgment of time, without any of that, well, bit of a controversy, I say. What do you say? Comment down below. Give me your feedback on this one, because I'm really curious what people's thoughts are on this case. This is a controversial case, and I'd like to hear from you. And then after you've watched the end of this video, please do click on like so I know if you like this video. Click Click on subscribe if you want to see some more of these videos, and hit that little notification bell so you know you get notification first when the next video is produced. Thanks for your time today. Cheers.